Hello and welcome to the Business Career College Continuing Education series of videos. Today we're going to be looking at privacy legislation in Canada, what privacy legislation is, and how you can best follow that. My name is Colin Johnson. I'm Director of Operations at Business Career College. I have a background in operations management as well as human resources management. Both of these are areas where I've had ample opportunity to learn about and apply privacy legislation, both with Business Career College and outside of my role here. I look forward to sharing some of my experience of what I've learned about privacy legislation, as well as some helpful tips in applying privacy legislation to your work as well. As we progress through the course today, we're going to look at 4 key areas. So we're going to look at what privacy rules are out there, and we're going to take an intense view of each of the areas that we focus on so that you can have a full understanding of this. And then we're going to provide you with additional resources so you can look further into those pieces of legislation as well if you see fit and want to learn more about them. Once we've built up that basic understanding of what privacy rules are out there, we're going to talk about how those rules will impact you, your company, the company you work for, and how you can establish some best practices to manage client privacy under that specific legislation. When we say best practices, really, it's just looking at some simple do's and don'ts for privacy management so that you can avoid any complications that might be out there. Once we've looked at each of the areas in privacy legislation, we're going to move on to some talk about why it's important to follow those rules. So we're going to look at 1, legal compliance. We're also going to look at what some of the financial implications of following those rules are, and then we're going to round that out with what I think is the most important reason for applying and adhering to this legislation, and that's the customer service aspect of it. The 4 main areas that we're going to focus on today are the Privacy Act, the Personal Information and Protection of Electronic Documents Act, Canada's anti-spam legislation, and then sector-specific laws. So the Privacy Act is a federal act. We're going to talk briefly about that and how it might apply to you. And we're also going to talk about its provincial equivalents. The piece of legislation we're going to spend the most time talking about today will probably be the Personal Information Protection and Electronic Documents Act, or PIPA. And then we're going to spend some time focusing on its provincial equivalents and letting you know where you can get more information about those. The second biggest piece of today's presentation is going to be Canada's anti-spam legislation. Now, while that isn't specifically a privacy law per se, there are a lot of the same issues contained in how to follow Canada's anti-spam legislation as we would focus on in the other areas, so it made sense for us to put this all in one place. And we're going to round the 4 areas that we're focusing on out with sector-specific laws. Now, there are a lot of sector-specific laws out there. We're going to talk about a few examples of the laws that are out there and talk about how they would apply as well. But we're obviously not going to talk about every law out there. So again, we'll point you to some resources that you can focus on to get more information there. I do hope that we can have a productive day today where you learn a lot of useful information that you can apply, as I say, in your everyday life, not in a way that becomes onerous, but hopefully in a way or some various ways that simplify everything for you and make it easy for you to comply with legislation. And we do hope you come up with a strong understanding of why legislation is so important to you as a professional in the insurance and financial services industry. Okay, so we're going to get started with talking about the Privacy Act. The Privacy Act is an act of the Government of Canada. And it may not apply directly to most of you in your day-to-day work, as it applies to federal government institutions, but it will apply to you as a consumer whose personal information is protected under the Act. So as I've said here, it applies to federal government institutions. So that is broken into two areas when we look at the Privacy Act. The first is departments and ministries of state. So that would be things like the Department of Foreign Affairs and so on, and an actual department of the government that carries on the work of running the government. And secondly, it applies to other government institutions. So other government institutions would be things like the Employment Insurance Organization or a nationally regulated board that does work on behalf of the government that actually isn't a specific department of the government. So anyone that's handling information on behalf of the government is covered under the Privacy Act. Now let's take a minute to quickly talk about what personal information is, because this act lays out regulations on how personal information is collected, used, and managed. So personal information is any piece of information that can be used to concretely identify an individual. So this isn't going to include anything which is part of the public domain or can't be used to identify you. So that would be things like your name is not considered personal information, your business contact information wouldn't be considered personal information because that can be obtained for commercial purposes. But things like your personal phone number, your personal email address, your age, any health information on you, all of that is considered to be personal information. So again, how that is collected, used, and managed by federal government institutions is laid out in the Privacy Act. Now, the Privacy Act is overseen by the Privacy Commissioner and their office. The Privacy Commissioner does have the authority to manage this act and investigate breaches of this act. And we'll talk about some more specifics of that when we talk about PIPA, because that same office manages PIPA as well. Now, when we look at this information, like I said, it applies to federal government institutions. But the provincial governments and their institutions also have regulations in place on how personal information is collected, used, and managed. So each province and each territory in Canada has an act similar to the Privacy Act that has to lay out at least equivalent levels of protection that are in the Privacy Act. In some cases, they are more strict conditions than you would see in the Privacy Act. Now, we are going to post some links for you in your course where you can go and look at the actual text of the Privacy Act, see the full implications of that, as well as a fact sheet about where you could contact the Privacy Commissioner, how you could file a complaint if you had issues under the Privacy Act, and so on and so forth. Welcome back to the Privacy Legislation in Canada course. We're going to continue this section talking about the Personal Information Protection and Electronic Documents Act, which can be quite a mouthful. So going forward, we're going to refer to this as PIPA, the acronym for that act. So PIPA governs the collection, use, and storage of personal information for business purposes. The section we just completed on the Privacy Act talked about the collection, use, and storage of personal information by federal government institutions. This act is about that same information for business purposes. We're going to specifically be focusing on Part 1 of PIPA. Part 1 is the part that refers to agencies that are in the private sector. So PIPA is a federal act, which means it was passed by the Government of Canada, and it applies everywhere in Canada. However, there are certain provinces that have passed acts similar to PIPA, including BC, Alberta, and Quebec. In these three provinces, the acts are similar enough and cover more than what is covered in PIPA, so the federal government has said that these acts replace Part 1 of PIPA. In any other province, there may be provincial privacy legislation that would cover the use, the collection, use, and storage of personal information for business purposes, but the federal government has not specifically said that they're strong enough to replace Part 1 of PIPA. We're going to take a look again at what personal information is specifically under PIPA. So personal information is about an identifiable individual and doesn't include their name, their title, or business address or business telephone number of an employee of an organization. So that when they say identifiable individual, we are looking at information that can be used to point out a specific person with the information that's out there. So anything other than those four things that are laid out specifically above, which come directly out of the privacy legislation, anything else would be considered personal information. So information about a health condition, your age, your gender, your personal contact information like your home address or your personal email address, all of that can be used to point out specifically who you are. So all of that is covered under PIPA as personal information, and under PIPA it is protected. So PIPA has five main areas that it focuses on. The first is around consent for collection of information. So that means that as a business person, you can only take information if the customer or the client consents to provide that to you. And part of consent is understanding that why they're providing it to you. So if you, for example, are collecting information for an insurance application, you have to tell the client the reason you're collecting that information, most likely for underwriting and classification purposes for the insurance, and that information is a criteria for the insurance. If they don't agree to provide that information, you can't collect it. But the flip side of that would be if they don't agree to provide that information, you likely won't be able to complete the application. The second part of what we're going to look at is that personal information can only be released with the consent of the client. There are a few exceptions to this, but unless you have talked to the person who provided you the information and they've given you express authorization to give that information to someone else, you can't provide that information to anyone for any purpose. A best practice in this area would be to get written consent from them if you're going to provide that information to someone else, because if something does happen, you would want a position to fall back on if the client said that they didn't give you consent to release that information. The third piece of PIPA is that personal information can only be used for the purposes that it was collected for. So if you are telling a client that you're collecting their information for the purposes of an insurance application, you have to use that information for the insurance application. If you're going to use the information for a different purpose, you have to let the client know about that, and they have to agree for their information to be used for that additional purpose. A good example from our industry and business career college would be if someone signed up for a course to qualify for their life insurance license with us. The information that we receive for that can be used to manage their life insurance course progress. But if they wanted to come back later on and do a financial planning course with us, they would have to provide that information to us with consent to use the information for that other purpose when they signed up for the other course. That's the reason that we, for example, get a student to fill out a new registration form each time they register for a course, so that we can be sure that a student is understanding why they're providing the information to us. The fourth part of the Act is the role of the Privacy Commissioner. And basically what the fourth part of the Act says is that the Privacy Commissioner can investigate breaches of the Act. So they look into any problems that may come up in regards to a complaint or poor storage of information. And then in addition to that, the Privacy Commissioner can audit personal information management practices of a business. Now, that doesn't mean that the Privacy Commissioner necessarily has access to anyone's specific private information. It's specifically the information management practices of a business. So what that means is the Privacy Commissioner can look at how you store someone's information, how you tell a person how you're going to use their information when you collect it, and how you dispose of a person's information once it's no longer needed in your system. Now, those three pieces are the key parts of what a business does with information. They collect information, and you always have to collect it in a way that's consistent with getting consent and the person understanding why they're providing it. How you store information, it has to be secure and it has to be retrievable. How you use information, again, only the way that the client has accepted that you'll use that information, and how you dispose of information. So it's equally important that once you're finished with using a person's information and you're no longer going to use it, you should be disposing of that information so that it can't be retrieved from your system maliciously. Now let's take a look back at the second criteria on this slide here, that personal information can generally only be released with the consent of the client. Now that's true, and that's the rule of thumb that you'll want to work with, that you should not be releasing information without a client's consent. But there are some very specific times in which you can release personal information without consent. So those exceptions are really, there's three exceptions that we're going to look at. And the first is that consent is not needed to collect or release information when it's part of legal proceedings. So if the police or the court system are requesting information or are collecting information about a person, they don't necessarily have to follow the same regulations as a business might need to collect that information. Because there's a legal proceeding involved, the person may not be as cooperative to provide the information and may hesitate to provide that information, so the proceeding couldn't be completed if full consent was followed in that case. A second illustration of that would be if the government is undergoing an investigation. So if they're collecting information on for example, a fraud claim against a government department, perhaps around the Canada Pension Plan, they also may have an exception to consent here that they could look at. The third area we're going to look at is actually a new development to note. An amendment to PIPA received royal assent, which means it went through government in June of 2015, and that's called the Digital Privacy Act. So in this update, one of the key things that was put in place is a new exception to consent was added. And this exception to consent is around the insurance industry. And what it says specifically, I've copied it word for word into this slide here, is that information produced by a witness statement when the collection is necessary to assess, process, or settle an insurance claim does not require consent. So in those cases, you would not need consent if you were adjudicating a claim. Now, if you were releasing or collecting information without consent, because these are special exceptions to the law, it would be a good idea for you to seek legal advice or your company to have a legal position on this before you made an exception to this. I would never want to advise that in all cases that these exceptions are going to be upheld. And I am not a lawyer, so I wouldn't be providing legal advice here. So you'd always want to seek legal guidance if you were making an exception to consent. Now, I want to take a moment to pop back to the classification of personal information now that we're talking about consent for use, collection, and release of that information. If you have employees, the information of those employees is also considered personal information because you'd have access to information like their age, their home address, you may know about personal health considerations, and so on. These same pieces of legislation would apply to you regarding that employment information. So employment information is collected to manage an employee of your organization, so you wouldn't want to use that outside of your organization. And if you wanted to use that information outside of your organization, you'd always want the employee's consent before you transferred any of that information. This is one of the reasons why often when someone is seeking a reference, you would ask for their agreement for you to contact previous employers about their employment history, because without their consent, those previous employers would be very limited in their ability to provide information, and really speaking, the things that they would be able to release are the things in this list that we see are not included as identifiable information. So that would be the name and title of the individual. So they could tell you perhaps that they worked for their company as an administrator, but beyond that, they may be very limited to provide you information without the consent of the employee. So looking back to the 5 points that PIPA covers, we're now going to focus on the last 2 points, which are really about the role of the Privacy Commissioner under PIPA. Like we said when we were discussing the Privacy Act, the Privacy Commissioner also is the person who's in charge of compliance with the Privacy Act, but now we're going to look at their role under PIPA and what they can do and what their role is to make sure people are following the regulations that are set out under PIPA. So the Privacy Commissioner does manage the regulations, and they can, if they have a violation brought to their attention, or if their department believes there's a violation, they can investigate that violation. There's a very detailed process on how they would handle an investigation. Once they complete their investigation, they will report that there is a violation. That is one of their responsibilities under the Act, is that they do have to report violations publicly. And additionally to that, they may suggest remedies. So when we talk about suggesting remedies, if they're investigating a privacy breach where you gave information out about one of your clients to someone without their consent, they may suggest, for example, that your business have a policy in place around when information can be released and how it would be released, and then keeping a record of that request on file. If it wasn't a breach of the Act like that, where perhaps you accidentally released personal information about the client to someone that you thought was the client, they might then in that case suggest procedures that you can put in place to verify that you are in fact talking to your client before you confirm things about their personal information. This is one of the reasons that we see verification questions when we call into a service provider, because they want to make sure that you, in fact, are the client that they're talking to so that they can manage their privacy responsibility. Now, once this investigation is completed and the violation has been reported, and even if remedies are suggested, there's a second piece around compliance, which is outside of the realm of regulation by the Privacy Commissioner, but it's about the relationship between you and the client whose information we're talking about. So if you are maintaining a client's information securely, you're only using it for the purposes you collected it for, and you collected it with consent, and you dispose of it once you're done with it properly, then you shouldn't have any problems with the privacy commissioner or with any individuals. But if there is a problem in any one of those areas, an individual can take legal action against you if you're in violation of PIPA. So as we said, that would require first the privacy commissioner to review and investigate the violation in question and report that violation. Once it's reported, someone could take legal action based on what actually happened in the specific case. That person could be awarded financial damages that would have to be paid by you, the person who was improperly maintaining their legislation. So that's one of the things we'll look at later when we talk about compliance generally, is there's a financial penalty potentially for not following PIPA. Not a financial penalty from the privacy commissioner. They can't issue you a fee, but if a person takes you to court and it's found that you did not protect their information well enough, you could end up with a fine due to that. So let's take some time now to look at some of the easy things that we can do to prevent problems with PIPA. So some of our first category of best practices is around protecting the information. You always want your business's information to be secure, but when we're talking about that in terms of PIPA, we want personal information that you've collected from clients to be protected. So if you took it in a physical form, if you were taking notes as part of taking an insurance application, you would want to make sure that you keep those physical files in a secure location. So that should mean that the files are put away when you're not using them, and at the end of the day, they're locked up so that no one can get access to them after business hours. During the day, if the area where the records are stored is supervised, it may not need to be kept locked. But if it's in a public area, you may want to keep that locked all day, not just at the end of the day. When we look at electronic information, the first step is protecting the device where the information is stored. So your computer should have a password. One of the reasons for that is that that's the first line of protection for the personal information. And inside the computer, whatever database that information is stored in should also be password protected. So even if it's a simple electronic place you're storing the data, so if you save it in a Word document and it's personal information that's stored there, you should apply a password to that as well, just so that that person's information is protected and you're respecting their privacy. This is also important when we look at removable hardware. So that means things like external hard drives or memory sticks. So if you're moving information from one computer to another using this removable hardware, that removable hardware, if possible, should be password protected. And then the documents within that, or the spreadsheets within that, should also be password protected. Now, these days, I more and more am sending information electronically, and it's important to keep that electronic information secure. So if you store information in the cloud with a service such as Dropbox or another private file server that's accessible online, you should always have a password to sign into those, and you should regularly keep those passwords secure. So that means things like not using simple passwords and changing your password regularly. The other way that we often send information back and forth is through email. Now, I know firsthand from emails that I've received, and unfortunately from the occasional email that I've sent, that if you're in a hurry, it's pretty easy to send the incorrect email or the correct email to the incorrect contact. So my name's Colin, and I deal with a service provider who also has a Colin that works on their staff, and sometimes accidentally I'll get an email intended for that other Colin. Now that could end up with a breach of personal information. So it's incredibly important that before you send an email, you do a quick read through that email and make sure that you're sending the right email to the right person. So you're reviewing your who you're sending it to. Make sure that you're only sending it to the people you're intending to send it to, and then take a quick read through the email as well to make sure that the information that you're sending is all correct. So that if it has personal information, it's only personal information that the people in the email should be able to see, and that it isn't information about someone else that they shouldn't be able to see. Another quick tip that can help protect you somewhat if you do send an email accidentally is including a footer in your email. So the footer I've included here is just one example of what you might want to use. This is taken from a best practices site on privacy. So what it says at the bottom of the email is this email may be privileged and or confidential, and the sender does not waive any related rights and obligations. If the reader is not the intended recipient or agent, please be advised that any dissemination, distribution, or duplication of this email or any of its attached documents is strictly prohibited. If you receive this email in error, please return the message to the sender by replying to it and then delete the message from your computer. So that is somewhat of a complicated message, but really it's saying a few key things to you, to your client, and to everyone that received it. So the first line is saying that the email might contain privileged information. So you're asking them, please be careful with this email. And you're also saying that it should not be disseminated, distributed, or duplicated. So you're saying that you want them to protect the privacy of this person as well. And then, and the last part of it, you're putting a call to action there. So you're saying, if I sent you this email in error, let me know that I sent it in error so that you can follow up regarding this. And then you're asking them also to delete the message. So that's some of the technical things that you personally could do to help you follow PIPA. Next, we're going to look more at the whole business side of things in creating a culture of confidentiality. What this means is creating an environment in your workplace, even if you're an office of one person or an office of 600 people, where confidentiality is viewed as a very important part of the business. So the first thing, and this is actually links back to restrictions that are in place under PIPA, is you should have a privacy officer. So everyone under PIPA needs to have someone that's in charge of privacy issues. Typically, it's someone in a more senior role in the organization. And basically all that means is someone who's in charge of making sure that PIPA is upheld. So if you're a private business person who you're the only employee, you are the privacy officer, so you're the one in charge of making sure that PIPA is upheld. If you have multiple people, you may want to appoint someone else. Now, it doesn't have to be named a privacy officer, but when you call someone a privacy officer, it creates the impression that privacy is important to your organization. And that goes take steps in direction of making people understand that confidentiality is an important part of the culture of your business. The second step is making sure that everyone's training includes training on confidentiality. Now, that doesn't specifically mean any technical training on PIPA, but it does mean that you should be making everyone in your organization aware of why confidentiality is important, what the benefits of maintaining confidentiality are, and what the consequences of lacking confidentiality might be. That doesn't necessarily mean the consequences of a breach of PIPA. That could mean what your company will do if there's a breach of confidentiality. So by putting in place breach of confidentiality measures within your company's policies and procedures, you're telling your employees that confidentiality is important. Now, beyond that initial training and the policy work that we talked about there, you also regularly want to review confidentiality and privacy issues. So on a regular basis, you want to look at regulatory changes that are out there. Now, a good example would be the Digital Privacy Act that I talked about, which was just passed last year in 2015. If I had worked based on my resources from 2013, I wouldn't have known about the changes due to that act. So it's very important on a regular basis for your privacy officer to be aware of any changes to the legislation that's out there, and then to regularly communicate those changes to everyone that needs to know about those specific technical regulatory changes. And then equally important is doing a refresher training on confidentiality and privacy to all of your employees, even if there aren't any changes. So if every year you get people to review confidentiality and review privacy, every year you're telling them confidentiality is important to us. Yes, I know you may have seen this information before, but it's still important for us in maintaining confidentiality of our clients. Welcome back to the Privacy Legislation in Canada presentation by Business Career College. Next, we're going to take a look at the Personal Information Protection Act. Now, this is an act that replaces PIPA in certain provinces, as we discussed earlier. So we're going to focus most directly on BC and Alberta for this section of the presentation, although there are some implications for other provinces as well. So in Alberta and BC, both provinces have an act named Personal Information and Protection Act, or PIPA for short, and PIPA protects personal information under provincial legislation. Now, a similar act was passed in Quebec, which is the Protection of Personal Information in the Private Sector Act, and the federal government declared that all three of these acts are substantially similar to PIPA and will apply in these provinces instead of PIPA. In Ontario, the Personal Health Information Protection Act has been deemed substantially similar to PIPA, but only in regards to health information. So when we talk about PIPA, we're talking about all personal information in Alberta and BC. The protection of personal information in the private sector applies to all personal information in Quebec. And then the Personal Health Information Protection Act applies in Ontario, but only to health information, not to all personal information. So the principles that PIPA is based on are the same principles that PIPA is based on, which is why the federal government deemed the act substantially similar to PIPA. We'll take a detailed look at these principles next. One of the key differences is in PIPA, the word organizations is used more heavily than you would see in PIPA. So under PIPA in both Alberta and BC, organizations are accountable for the protection of personal information that is under their control. The purposes for which the personal information is being collected must be identified during or prior to the collection. So that's just the same as we saw with PIPA. You have to explain why you're collecting the information. The third point here is talking about consent. So just like under PIPA, you have to have consent to use or disclose or collect any personal information. The fourth principle that we look at is that personal information can only be collected for the reasons, again, that you are collecting it for. So if you're taking an insurance application, you can only, again, use that information for the purposes of an insurance application, not for other business purposes. Additionally, personal information must be as accurate, complete, and up-to-date as is necessary. One of the differences in PIPA over PIPA is a symptom of when it was written. PIPA is a more recently updated act than PIPA. So in PIPA, there's a large focus on consumers having access to their information at any time, barring specific regulatory times when they can't have access to it, and allowing individuals to update their information whenever they need to update it so that all of the information is always correct. PIPA goes on to talk about the fact that personal information must be protected by adequate safeguards. So as we were talking about best practices under PIPA, again, you would want your information that you're collecting to be protected with passwords, or if it's in a physical file, to be kept in a locked location. Organizations also have to share their privacy policies and practices with individuals who have information stored with that organization. So if you have a client who wants to know what your policy on protection of information is, you do have to provide them information on that within a timely manner. As I was saying before, one of the key differences here is a heavier focus on access to personal information. PIPA is on providing individuals with the right of access to their personal information about themselves, except for some exceptions as specified in statute, so in law. And then organizations must provide the means for an individual to challenge your compliance to the above principles. So that means if someone thinks you aren't following the principles that are laid out here, they have the right to talk to the privacy agent for that jurisdiction, so for BC or Alberta or Quebec, and that person, that privacy agent would then look into your organizational compliance with PIPA as part of their investigation. Now, in these principles, there is quite a heavy focus on individuals versus organizations, and there are some specific definitions that we'll look at. The definition of an organization is a little bit different in every jurisdiction, but it may or may not be an incorporated body. It may be an individual acting in a business capacity. It may be a nonprofit association in some cases. We'll look at an exception to that later. Uh, it also can be a professional regulatory organization in Alberta. In BC, it can't be a professional regulatory organization because that's governed under BC's equivalent to the Privacy Act. The one thing to keep in mind, and this is why we use the word organization when we're talking about PIPA, is PIPA doesn't apply to individuals acting in a personal or domestic capacity. So if you're engaging in the activities of your everyday life and not doing business, and your home life, you're not subject to PIPA. You'd only be subject to PIPA if you are conducting business, whether you're working for someone else or conducting business on your own behalf. In both those cases, you'd be subject to PIPA, just like an incorporated company would be subject to PIPA. Now, as I said, there are some exceptions to these principles. Like I said, there's an exception in Alberta around nonprofit organizations, and there's exceptions around professional regulatory organizations. So next, we're going to take a moment to look at those specific exceptions. Under PIPA, there are really two broad exceptions that we're going to look at. So certain nonprofit organizations in Alberta are not subject to PIPA for most of their activities. They're only subject to PIPA for their commercial activities. So when a nonprofit is engaging in commercial activities, they would be subject to PIPA, generally speaking. When they're engaged in charitable activities or nonprofit activities, they wouldn't be subject to this. The reasoning behind this exception in Alberta is a number of politicians argued successfully that PIPA and following PIPA was too onerous for nonprofit organizations, and the cost would take away from their nonprofit work. The second notable exception that we'll take a look at here is in both Alberta and BC, when an organization is subject to PIPA, and they engage in commercial trans-border personal information flows, they also have to follow PIPA for those specific transactions. So let's just break down that statement a little more. So what a trans-border personal information flow is when your personal information, for one reason or another, has to be transmitted from from the province where we're looking at PIPA to another province. So if, for example, you were located in Saskatchewan, buying something from someone in Alberta, the organization would be responsible to follow Alberta's PIPA regulations for your personal information, but also the PIPEDA regulations for your personal information. Because the regulations are substantially similar, this shouldn't make a huge difference in how it's handled, but there may be a few extra things to keep in mind. Building on these two exceptions, there's a third major exception that we're going to look at. In it's important to recognize that even some industries in BC and Alberta are not subject to PIPA. The reason for that is because of the type of work that they do. So there's really two types of organizations that aren't subject to PIPA and are always going to be subject to PIPEDA. The first one is called Federal Works, Undertakings, or Businesses. Now, in the Act and the legislation, you'll often see the abbreviation of FWUBs for these. Now, there are a lot of examples of federal works, undertakings, or businesses, but the key thing to keep in mind is these are generally the types of businesses that are federally regulated. So when we were talking about PIPEDA, we were talking a little bit about federal regulations. And later in this course, we'll talk about industry-specific regulations, where this will apply as well. So some examples of federal works, undertakings, or businesses would be banks, radio and television stations, interprovincial trucking companies, airports, shipping companies that are shipping by water, and then telecommunication companies like internet service providers. Also, railways and pipelines that cross borders would be federal works, undertakings, or businesses. Now, the second type of activity is commercial activity that crosses borders. So even if you are a company that is based entirely in BC, but you make deliveries just across the border into Alberta or just across the border to the US, in those cases, you would also be subject to PIPEDA because you're working outside of BC and outside of Alberta. Even if you were located in BC and you were operating in just Alberta, you'd still be subject to PIPEDA. So other than this, PIPA is going to apply when it's a provincially regulated activity, which most commercial activities are provincially regulated. And then with both of these cases, if there's employee information involved, it falls within the same regulation. So if you're a federal work undertaking or business handling employee information, that would be handled under PIPEDA. And if you're a provincially regulated organization handling employee information, that employee information, just like any other personal information, would be handled under PIPA. So next we're going to look at the differences in compliance between PIPA and PIPEDA. So you'll remember that under PIPEDA, the compliance was managed by the Privacy Commissioner. Now, under each privacy law in PIPA, a commissioner is designated for overseeing the application of the statute and investigating disputes between individuals and organizations. Now, that organization that manages compliance is different in each province. So in Alberta, it's the Office of the Information and Privacy Commissioner of Alberta. In BC, it's the Office of the Information and Privacy Commissioner for British Columbia. And in Quebec, it's the Commission d'accès à l'information de Québec. So really, in all cases, it's just a variation on saying Privacy Commissioner. So it's the same title in each of the provinces. And now we're going to take a quick look at what enforcement looks like in those provinces. And again, it's very similar to PIPEDA. So the privacy officers for PIPA can investigate breaches of the Act. They can report violations of the Act, and they can suggest remedies for poor conduct, just like we saw under PIPEDA. Again, the privacy officers aren't issuing fines to organizations. They're focused on improving the behavior and making the public aware of what individual organizations are doing in terms of their conduct around privacy. But also, like under PIPA, individuals can use the court system to take legal action uh, against organizations if they're in violation of PIPA. Now, just like with any piece of legislation that we're going to look at today, we want to look at ways that we can simply and easily help you avoid these enforcement actions under PIPA as well. So we've put together some best practices, and you'll recognize these as similar to the best practices that we looked at under PIPA. So the first best practice that we're going to look at, again, is protect the information that you're entrusted with. It's important that you respect your clients and your customers and your employees' privacy. And you can show that you respect that by keeping that information secure and protected. So just like we talked about under PIPA, physical files should be secure. That means when they're not in use, they should be put away in a secure area, and they should be kept locked up when they're not at use in times such as overnight. If you are actively using them, you can have them out, but they should always be under your supervision and under your custody. That's one way that you can ensure your customers understand your desire to respect their privacy. When we're looking at electronic records, we want to do the same thing. We want to keep those files secure. So your computer itself should always be password protected if it has client documents on it. If you're keeping the personal information in a Word document or a spreadsheet or a database, that instrument should also have a second password on it. That makes certain that that information is extremely secure and that only authorized individuals should have access to it. When you're talking about computers and databases, remember that if your information is stored in the cloud or if you have a removable device, those should also be kept secure. I'd also like to take a minute to reflect back on the idea of a culture of confidentiality again. So the same principles that we talked about before under PIPA would apply. You as an organization need to have a privacy officer, someone that's responsible for following PIPA, and someone that encourages that culture of confidentiality and is a champion for confidentiality and privacy within your organization. When it's a person who truly cares about that and truly understands why that's incredibly important to a customer, it's going to be easy for them to focus on doing privacy and confidentiality right in your organization. And then always remember to review every chance that you get, confidentiality and any changes to the regulations that are out there. The third point that is extra important under PIPA because of its focus on access to personal information by the people that provide the information is openness about your practices. So any individual that has personal information stored with you, like we said, can request access firstly to whatever information you have stored about them, and you need to provide that access to them so that they can see that their information is correct and up to date and stored properly. Secondly, you also have to provide access on request to your policies and procedures regarding how you store that personal information. This is why it is best when you're in a PIPA regulated province or in any province really to have written policy and procedure around personal information, how it's going to be treated, collected, and used. By keeping those three broad best practices in mind, you can always be sure that you're protecting yourself against potential problems with privacy legislation violation, specifically around PIPA. Because just like with PIPA, even though there isn't necessarily a direct financial penalty, there is the potential of court action out there, and you want to maintain that strong responsibility and that strong reputation with all of your clients. Thank you for coming back to the privacy legislation in Canada presentation. So we're going to focus on Canada's anti-spam law next, also known as CASL or CASL. You'll often hear it called CASL because Canada's anti-spam law is a bit of a mouthful. This area does have a lot of acronyms, and I will use some of them, but I'll try to define them as we go through. So what Canada's anti-spam law does is it dictates the do's and don'ts of electronic communication, including commercial electronic messages. The other aspect of the regulation is it also regulates installing software on someone else's computer. So if you're engaged in a business where you do that, you'd want to refer back to the CASL legislation that we have a direct link to in your Moodle resources and specifically look up those regulations because in this privacy presentation, we're specifically going to look at electronic communication and commercial electronic messages. When we look at electronic communication, CASL regulates this in three areas. The first is consent, which you'll remember from the section on PIPA. Consent is a little bit different in this area, but the basic premise is still the same. The second area is identification, and then the third area is unsubscribing. Consent and unsubscribing are both to deal with whatever the customer's requests are under CASL. Identification is about the information you as a business have to provide in your electronic messages. The big difference between direct privacy legislation like the Privacy Act and PIPA is in those types of legislation, specifically the Privacy Act applies to the public sector or governments, and PIPA applies to the private sector or corporations. CASL applies to all commercial electronic messages regardless of what industry that someone is in. So if a commercial electronic message is sent by someone in the government or someone in a private company, both of those are regulated under Canada's anti-spam law. So we'll get started with talking about what a CEM is. So this is one of those acronyms I talked about. It's a commercial electronic message. So what that means is that I'll break it down into two parts, the electronic message part and the commercial part. So an electronic message, as defined by CASL, is any communication that's sent by means of telecommunication. Most commonly, this is regulating email messages or text messages, but this would also apply to an online instant message. It could apply to you directing someone to a website through an electronic message. It also could, by this definition, apply to a message that you send by fax as well, because telecommunication means any message that's sent digitally or electronically. So the second part of CEM is the commercial part. And what that means is that a message is commercial if the content in your message is leading someone to engage in a purchase or other financial exchange with you. So if you're trying to get them to buy one of your products, or perhaps invest in your company, or make a donation to an organization that you're representing, all three of those things would be considered commercial purposes. So always keep both parts of this in mind. So is a message electronic? So are you sending it by telecommunication? And is it commercial? Are you trying to sell something? So now that we have mastered the definition of a commercial electronic message, we're going to move back on to the three things that are regulated within commercial electronic messages: consent, identification, and unsubscribing. Under CASL, consent can be of two kinds. It can be express consent or implied consent. So express consent is when your customer is specifically giving you their authorization to be able to communicate with them for commercial purposes. So when you buy a lot of products, you'll often see a little statement at the end of the purchase asking if you want to receive updates and other offers from the company. That is that company asking you for express consent. So if you check that box off, you're saying that for as long as you want, you can send commercial electronic messages to me because I have agreed to this. The second kind of consent is implied consent. Now, implied consent is the consent you receive by someone having purchased something from you. So when someone purchases a product or other service from you, if you are advertising a related product, you can send them commercial electronic messages about that under implied consent. It's based around what a person could reasonably be expected to expect for information from you about. So what you sell should be reasonably related to the product you've sold them. One thing that we use implied consent at Business Career College around is if someone buys our life insurance self-study course and we may send them information about seminars to help them prepare for the exams for that course if they have given us implied consent. Now, regardless of which type of consent a person gives you, they can withdraw that consent at any time, and you're required to stop sending them commercial electronic messages. Like I said, they can withdraw that consent at any time. It could be when they purchase with you, they could say, I don't want any electronic messages. Then even your implied consent would be gone. It can be just after, or it can be years down the road. Now, as soon as you get that consent, you should stop sending the messages as soon as possible, but you do have up to 10 days to stop sending those messages. We'll look more specifically at that in the section on unsubscribing. The second regulated part of commercial electronic messages is identification. And like I said, identification is about identifying the business that's sending that message. So let's look at some more specifics on what's required in identification. So we are required to identify 4 main things when we send a commercial electronic message. Now, these 4 things are intended to clearly identify who the sender is. So the first thing is the name of the business. So in every commercial electronic message, you want to identify the name of the business. So this is a sample of a commercial electronic message that we from Business Career College might send. I've highlighted 3 parts on this message where you can see the name Business Career College. This is how we are identifying the name of the business who's sending the commercial electronic message. The next thing that you want to identify is the name of the sender and the identity of the sender of the message. So this means the specific person who's sending this message out to you or out to the client. So again, in this example of a message, we can see that Kelly, a person in our marketing department, sent this message out, and we've identified Kelly with his email address in the first or second line of this email. So you can see that this has been sent from Kelly at businesscareercollege.com. The third and fourth parts that you want to identify in a message are the physical location of the sender, the email address, phone number, or other contact information of the sender. Now, the physical location is required in the commercial electronic message, as well as some other way to contact the sender. You don't have to have the email address, phone number, and another contact method for the sender, but you need at least one of those things in place. Looking for a third time at this same commercial message, you can see that at the bottom of the email, we've highlighted in orange and pointed at it with a green arrow our physical address. So this is the physical address of our head office of Business Career College. Now, the other 3 highlighted areas in this commercial electronic message are ways people could communicate with us. Now, you don't have to have all 3 of these, but we have Kelly's email address, we have our toll-free phone number, and we have our website. Any of those three things would be good enough to provide the contact information for the sender of the message. So just as a review, your message has to include the name of the business, in our case, Business Career College, the name of the sender, in our message it was Kelly, the physical location of the sender, that's where we had the address of our head office, and then one of the three ways of communicating with the sender, either email address, phone number, or some other defined way of communicating with them, like our company website in our case. The third part of regulations on commercial electronic messages is unsubscribing. So let's go through that in a little more detail. Now, every commercial electronic message has to have a clear and simple way to allow customers to understand how to stop communication from you. That's all unsubscribing means, is it's a way for a customer to stop the communication from you. Now, these details, like I said, have to be in every commercial electronic message that you send. So even if you've sent 10 other commercial electronic messages to the same person, if in the 11th message you don't have a way for them to unsubscribe, you're not complying with Canada's anti-spam law. So it has to be there every time you send it. All of these three things have to be there every time you send a message. Now, once you have a way for someone to unsubscribe, you have to make that change within 10 days. And then the fourth part of this is that you can't charge a fee to unsubscribe the person. So you want to have some free way that the person can unsubscribe from your messages. Now, there are a few different ways you can look at this. One would be a line at the bottom of your email telling someone to stop receiving messages. Please email callin@businesscareercollege.com, and we'd be happy to unsubscribe you. Now, we in our emails use a direct link that I'll show you in the next slide here. So we use a service called Safe Unsubscribe. You can see it highlighted and indicated with a blue arrow at the bottom of this slide. When a customer sees this email, it would say Safe Unsubscribe, and then where it says recipient's email, it would show their email address. Once they click on that, it asks them to confirm that they want to unsubscribe from emails from Business Career College, and once they do that, their commercial electronic messages are automatically stopped. Now that we've reviewed the rules around Canada's anti-spam law, I'm going to talk to you a little bit about compliance to Canada's anti-spam law. So compliance with CASL is managed by the CRTC. That stands for the Canadian Radio, Television and Telecommunications Commission. This is not the police and it's not the government themselves. This is a government agency. So unlike the Privacy Act and PIPA, which were managed by the Privacy Commissioner, this act is managed by an outside government agency. Now, the CRTC is the same group that manages compliance with regulations around Canadian television content, as well as the rules on cell phone service provision and internet service provision in Canada. So you may be familiar with the CRTC from there. Now, if you're in violation of CASL, CRTC can issue warnings or fines. What they've stated on the Fight Spam website that is in place to give you updates about CASL is that they would prefer to first issue warnings and corrections to you, and that their intent is only to issue fines when someone is regularly and egregiously violating CASL. But when it comes to the fines, if you're an individual, you can be fined up to $1 million per infraction, and if you're a business, up to $10 million per infraction. So that's a very large financial fine. And this is the first time that we see an act that is enforceable directly by a fine. If you remember, when someone's in violation of PIPA, they can be sued by someone through the court system, but the Privacy Commissioner can't issue a fine directly. Under CASL, you can be issued a direct fine. So now that we've looked at the compliance piece, let's turn and look at some ways that we can prevent some of these negative things from happening. So let's look at the best practices for CASL. So I talked a little bit earlier about our unsubscribe mechanism, and that's part of an email marketing program that we use here at Business Career College. This program is a dream for me in terms of CASL because if we use that program, it almost completely eliminates the potential for us to be in violation of CASL because it builds all of the protections into the system regarding CASL. Right from the very start, when we put a person's email address into our email marketing program, it asks us if we have consent. If we don't have consent, it won't allow us to add them to the program. So we've already started off on good footing there. Once you say that you have consent, it asks you if it's express consent or implied consent. If it's implied consent, it applies the timeline of how long that consent is valid for automatically to their email address, and then we'll remove their email address from the system once that time expires. So we've already got the first piece of consent covered by using this marketing program. The second piece, identification, is also covered in the program. So all of the times we saw the contact information and the physical address in the example email that I showed you, that is put in there by the system and we can't remove that. So it forces you to put the physical address and the contact information in your commercial electronic message. The third thing it manages for you is the unsubscribe process. And like I said when I was talking about the unsubscribe, as soon as a student uses that unsubscribe button, our email marketing system will no longer let us send an email to that student. In fact, it will keep that email unsubscribed until the student logs in and updates their preferences with us. So if we want a student to get emails again, even if they tell us that they want those emails, we have to send them a link to update their information in our system. So an email marketing program can be inexpensive, and it can cover all of these things for you, eliminating a lot of the worries around commercial electronic marketing messages. Now, I said it virtually eliminates having to manage that. We do need to train ourselves and all of my reports on what they need to know about CASL because they may send a direct email to a customer not thinking it's a commercial message. If they do that, they just have to make sure they have those three things in there again. So they've gotten consent to send it. They've identified the sender in it, and they have a way for the person to stop receiving messages and unsubscribe that person when they request it. CASL maintains a website called fightspam.gc.ca. You know it's a government website by the .gc.ca ending, so it is a trustworthy source and the best source for any updates about CASL. And we've also included one of their documents, Protect Your Organization from Threats, in your Moodle course materials. This is more specifically related to the download of programs on other computers and general protection of information under CASL. But CASL has many bulletins and infographics on their website, and I encourage you to visit their website and make sure you're completely up to date on everything that they've posted there, because it does change from time to time. Welcome back to our presentation about privacy legislation in Canada. We're going to move on now to a short section on sector-specific laws. Now, because there are many different sectors, all of which have their own legislation, we do always recommend that you research whether your specific sector has any laws governing it. But we're going to talk more specifically about how these laws interact with the other privacy laws that are out there. The sector-specific laws could be federal regulation or provincial regulation, depending on the type of organization that we're looking at. So, for example, the Federal Bank Act regulates many aspects of banking for federally regulated banks. So typically there we'd be looking at the big five banks in Canada, but it does govern any federally regulated bank by the same regulations. So under the Federal Bank Act, specifically, it has provisions that relate to the collection of information and the protection and storage of that information. The information that it's referring to in those sector-specific laws are more specifically related to financial information. So these federal regulations aren't necessarily concerned rather with the collection of identifiable personal information, but they're looking more at the collection and use of financial information, like the information you might take when you were opening a bank account or applying for a loan for a client. And it also regulates the access to the credit bureau that banks have and what they have to do to get consent to access that information as well. Many of the same concepts that we talked about in the Privacy Act and PIPA do apply here in terms of acquiring consent and identifying how you're going to use the information and only using it for that purpose. But again, it's for a different type of information. It's for the financial information. When we look at a similar example at a provincial level, we can look at credit unions. So credit unions are not nationally regulated, so there can't be a national act that regulates them, but most provinces have a provincial act that has the same provisions in place or similar provisions in place that would regulate a federally regulated bank for a credit union. So again, regarding the collection and use of financial information. Now, in both of these examples, we're talking about banking authorities who are collecting financial information, but provincially there are also regulations around insurance. So you'd need to review the Insurance Act in your specific province to know what the regulations are there. In all three of these cases, the most important thing to remember is that just because there's a sector-specific law in place does not mean that you can ignore other laws. Just like we talked about with provincial laws and PIPA, PIPA will still apply even if there's a sector-specific law in place. So if you're working at a bank and you're collecting a person's information, when you collect their identifiable information to document in your system, you still have to tell them why you're collecting it and only use that information for the reasons that you've stated when you're collecting it. A lot of that similar processes will be used for managing their financial information to keep things simple. So one of the examples that I gave you of sectors that this applies to is banking, telecommunications, and airlines are two other sectors that have sector-specific laws which have some privacy implications. But again, you still have to make sure you're familiar with PIPA as well as your specific sector law. So when we look at an airline, for example, they collect a higher degree of personal information than one regularly might collect in the private sector because they'd have access to things like the content of the information on your passport. So they're more strictly regulated than a private sector business might be, who may only be collecting simple identifiable information like your home email address, your physical address, and a few demographics about you. When you're going to be on a flight and making a purchase from an airline, you have to provide a complete set of demographics, so they have additional scrutiny in place. Many of these sector-specific laws are more rigorous than PIPA and have more regular follow-up and compliance than we would see in PIPA. Now, when you're looking at best practices, the same best practices that we have in place for PIPA will help you with sector-specific laws. So you always want to protect the information of your client. So again, physical files should be put away and locked up. Computers and databases and external hardware should all be password protected at all times. Creating a culture of confidentiality, again, will help you with this process. So it's important that you're always using the best practices that we identify. If everyone believes that confidentiality is important, then your clients will understand that confidentiality is important to you, and you should have fewer breaches of your sector-specific privacy regulations. Thanks for returning to the privacy legislation in Canada video presentation. Our last section today is on reasons that it's important to be compliant, and then we'll be providing you with some additional resources that are available in your Moodle account and going over the exact contents of those. So as we proceeded through the various sections of PIPA and of CASL, we talked about some of the potential pitfalls that are there in terms of what can happen if you're not compliant with their legislation. But I wanted to start this compliance section on more of a positive note, talking about the benefits of why you should be compliant and why it should be important to you and your entire organization. If you can understand why it's important, then creating that culture of confidentiality should be a no-brainer in protecting you from violations against privacy legislation in Canada. So the first thing I want to talk about is goodwill. Goodwill and word of mouth is one of the strongest ways of building your business and building contacts in your business. When I was early on in my training for a sales job that I was previously in, one of the pieces that my instructor passed on to me is that it takes 5 times as many good words about your organization to reverse the impact of one negative experience that a person's had. And I can relate to that from my own experience. So I had student loans from when I went to university, and one of the things that happened with student loans a few years ago is an external hard drive containing the personal information of a large segment of student loan recipients was lost by an employee of the organization that manages student loans. I found this very frustrating and upsetting to myself personally because I take my privacy very seriously. So it will take a lot of attempts by the student loans group to rebuild that goodwill with me. I'd never had any other problems with them, but one single problem, even though it wasn't a minor one, has really destroyed my faith in them, and not just in terms of their privacy protection. So when you protect your clients' information and respect their privacy, your clients will come to understand that you respect them. And that helps you earn more business from them, creating that goodwill with them. In my example with Canada Student Loans, even though they hadn't done anything from their service perspective, I was still, I never look forward to dealing with them because I view them as an organization that doesn't value me as a client. So that's one simple example of why goodwill is so important. Related to goodwill, but slightly different, is your reputation as a business. So I like to view goodwill with clients as a business-to-client interaction, where that client's interaction with me is positive. Reputation is about how everyone out in the public views me. So when we talked about PIPA and how the Privacy Commissioner reports and publishes violations of PIPA, because anyone out there in the industry or outside of the industry can see that violation, whether they've dealt with you or not, that will impact whether they want to deal with you, and it impacts you on a very broad scale. So that strong reputation is very important. And again, it's much easier to maintain a good reputation than it ever will be to rebuild a bad reputation. So even if there's just one violation reported against you, if that happens to be the one violation that a potential client sees about you, it may mean the difference between them becoming a client of yours and not becoming a client of yours. The third broad reason to be compliant is to avoid legal action. So legal action is going to be expensive for you in terms of pursuing the court case, and could compromise, again, your reputation, but also your ability to pursue business in the industry. So many industries, including insurance, have restrictions on issuing licenses or maintaining licenses for people that have had successful legal claims filed against them. So again, we can never provide the legal advice that this would have your license removed, because I'm not a lawyer here, but there is always that potential. And even if it doesn't remove your license, there's the reputational damage that comes along with that. The fourth thing that people may view as the most important reason to be compliant is the financial penalties. In reality, this is probably the simplest of the penalties to manage, because as soon as you can come up with the funds to cover the fines or the financial award that's been there, that financial penalty goes away. It's not like the goodwill, reputation, and potential legal ramifications that we talked about. Not to say that the fine is a small thing either. In a business, we are always wanting to make sure we're spending our money in the best way possible. And if it's money that can easily be saved or fines that can easily be avoided by putting best practices in place, then we would definitely want to avoid having to pay those fines, because as we saw when we looked at CASL, for example, those fines can be very high for a business, anywhere up to $10 million. And even for an individual, they can be up to $1 million. So to review the actual acts that are in place, and to look at some of the additional resources that I've mentioned throughout these presentations, you can go back to your Moodle profile and look at the additional resources that are in place there for you to use. So we've included complete versions of the legislations described. The Privacy Act is there. The full act of PIPA is there, and Canada's anti-spam law is also there in full. Because of the variety of sector-specific laws, we haven't included those, but within the links, you will also find a link where you could search that legislation. It is one of the fact sheets that's up there, and that fact sheet contains a great deal of the information we've covered today, as well as further information on the topics that we've covered today. And we hope that you've learned a lot today. Best of luck. Your next steps to complete this course are to complete the quiz. Now that you've watched the final video in the series, assuming you've completed watching all of the videos for this series, you'll be able to access the quiz. And good luck in the industry, and good luck with your license renewal.